Okay, welcome to the Appellate Division First Department. The court is now in session. I will begin with a call of the calendar. People versus Luis Cruz. Appellant Cruz is given 3 minutes and one in rebuttal. The people get 3 minutes. Palau versus Pagan. Appellant Palau has submitted. The respondents will get 3 minutes as they wish to argue. W. Scott versus Cristia is submitted. G. Cristia versus Scott is submitted. Board managers, Peregrine Tower versus New York City 2014. Appellant New York City 2014 gets 5 minutes and 2 in rebuttal. Respondents board gets 5 minutes. Moldaver versus Pref 34th Street is submitted. People versus Frank Ellis is submitted. Ing Berman versus Colon. Appellant Ing Berman is appellant gets 7 minutes and 2 in rebuttal. Respondent Colon gets 7 minutes. JP Morgan Chase versus Peters and East 4. Appellant JP Morgan gets 6 minutes and 2 in rebuttal. Cross appellant East 4 gets the same amount of time, 6 and 2. New Canaan versus Chabon Park. Appellant New Canaan gets 5 minutes and 2 in rebuttal. The respondents get 5 minutes and 4 minutes. JG Jewelry versus Shri Kamkrishna. I'm sorry if I bungle that. The appellant gets 6 and 2. Cross appellant JG Jewelry gets 6 and 2 as well. WF Children is submitted. Philadelphia Insurance versus Kendall. Appellant Philadelphia gets 6 minutes and 2 in rebuttal. Respondent Kendall gets 6 minutes. Harvard Steel versus Bain. Appellant Harvard gets 6 and 2. Bain respondent gets 6. Hopkinson Associates versus Greenwich Villager. Appellant Hopkinson gets 5 minutes and 1 in rebuttal. Respondents get 5 minutes. McCabe versus Command. McCabe appellant gets 5 and 1. Respondent Command gets 5 minutes. Berger versus Signat Investments is submitted. Cefante versus City of New York is submitted. Napoli versus Byrne is submitted. First case on the calendar, People versus Cruz. Just give me 1 second.
Sure.
I apologize. I believe that I missed People versus Blanca Alvarez, which is number 12 in the calendar. Appellant Alvarez gets 5 minutes and 2 in rebuttal. The people get 5 minutes. I apologize for that. So first case on the calendar is People versus Cruz. Let me first hear from Appellant Cruz.
Yes, good afternoon. May it please the court, Shana Watrous on behalf of Luis Cruz. Luis cast significant doubt on his guilt when he repeatedly refused to agree that there had been a threat of force, an essential element of robbery. 4 times during his plea colloquy, Luis was asked if Donnell had threatened the complainant.
Counsel, sorry to interrupt. This is Justice Moulton. You'd concede that it's not necessary to tick off every element of the crime that's being pled to, correct?
Correct. Yes, Your Honor. But in a case like, sorry, go ahead.
Well, given that, don't the circumstances here provide evidence of an implied threat, particularly when he said that his accomplice was there to help him keep the money, quote unquote?
Your Honor, when he was explicitly asked about just this one kind of threat, like he kept being asked, did he threaten to push him? Did he threaten to do something to him? He kept saying, I don't know, I'm not going to say yes. And faced with that, the court was left with a doubt about whether he actually did this, which is why even after he said maybe he went up to him, the court kept inquiring because the court realized that this was an implied negation, and the court had a doubt about his guilt.
But he, I mean, I understand he was reluctant to implicate co-defendant, but at the end of the day, after the court tried twice, the defendant did admit that co-defendant was with him to help him keep the money, as Justice Moulton indicated, correct?
He did say he was there to help him keep the money, but that does not mean that there was any kind of a use of force or a threat of force. And that's really important. You know, whatever his motivation might have been for negating this element, the court needed to at least assure itself that he understood the charge to which he was pleading.
But admitting to his co-defendant is really not as to the element of force, right? That was more with respect to whether he was actually aided by another who was actually present, right?
So I think that the colloquy did confirm that there was someone else actually present, but it did not satisfy the element of whether there was a use or threat of force. And it just, there had been no allegation that there was a use or threat of force in any of the documents in the record. So it's really unclear that Luis would have understood that this was a required element of this crime, this serious crime that he was pleading guilty to. He was a 16-year-old who had dropped out in the 9th grade where he'd been in special ed classes. He had dealt with childhood drug and alcohol addiction since he was 13.
But he knew that the $20 was just not being given to him out of the goodness of the victim's heart, right? I mean, they surrounded the victim with his co-defendant, and wanted to make change with the $20, right? But we all know what that means in the street, right?
Your Honor, this court has held that when there's a request for money, as in this case when he's first asked to help his basketball team, and then when he's asked for money to make change, there was no allegation that this was any kind of a threat. And this court has held that even when you approach someone with a mean look and ask for money, even when the complainant might be afraid, that does not constitute a threat of force. And the court needed to be clear in this case that he understood that was a required element.
Taking the victim's money out of his wallet force? Assuming we buy the whole donate something for the basketball team routine, how do you get around he reached into the victim's wallet and then took $60?
This court has never found, no court has ever found that just reaching into someone's pocket or someone's wallet constitutes the use of force.
While surrounding them, right?
They stood next to him.
Can you infer threat or use of force if you don't comply from the circumstances?
Well, he also wasn't asked during the colloquy whether they surrounded him. Just the fact that they approached, it was alleged that they approached in the complaint, but nothing in the colloquy itself says.
The prosecutor said, and did Donnell Clayton threaten to push that person when you asked for money? I mean, he said he didn't know, but he was present, right?
He was.
They asked him following that up. The prosecutor then asked, were you present when Donnell Clayton the entire time when this happened? He said no, but then he was asked, was he present when you stole the money from this person on the subway? And he said yes. Yes,
and his presence, that does not mean, like I said, that doesn't mean that he was admitting to the use of force. Anytime he was specifically asked whether there was some kind of a threat, he said either I don't know or I'm not going to say yes.
Okay, let me hear from the people.
Good afternoon, Your Honors. Michael Tarbutton for the people. Your Honors, it's certainly true that the defendant's statement here did not negate the force element of robbery. At the very worst, he may have negated one particular factual scenario that could have supported the robbery element and left many others that are suggested by the record there. But it's important to remember that the court didn't have to elicit any factual facts supporting any of the elements of robbery at all. The only thing the court had to do is conduct a Lopez inquiry if the defendant actually negated an element outright, and that's not what happened here. As Your Honors have mentioned, the defendant here was trying to avoid implicating his co-defendant. He didn't, his counsel wanted the cases called separately. The defendant ultimately, I think, is very telling, says, "I'm not going to say he threatened the kid." He's no longer saying, "I don't know." He's not saying it wasn't there. He's just saying, "I'm not going to say." This is about his unwillingness to implicate the co-defendant. That doesn't suggest that he doesn't understand the force element of robbery, particularly since he's pled guilty to robbery before. So the only time the court has to conduct the Lopez inquiry is if he actually negates an element of the robbery outright or in some other way indicates he doesn't know what's going on, and that didn't happen here. Again, at worst, when he said, "I'm not going to say he threatened him," at worst that would suggest that the co-defendant didn't threaten the victim at that point, which is when he followed him after the money had actually been taken. And it doesn't even preclude that. The defendant implicitly in answering the court's question, the court said, "Isn't it true that the co-defendant that when the victim followed you, the co-defendant turned around and threatened him?" He says, "First he says, I don't know," then says, "I'm not going to say he threatened the kid." He's implicitly acknowledging that the victim did follow him, the co-defendant did confront him. If you take him at his word, he's saying, "I don't know what happened after that." And of course, according to this account, he's in flight. He wouldn't necessarily know what went on between the co-defendant and the victim. He doesn't know if there's an express threat. He certainly wouldn't know if there's an implied threat. He wouldn't know if there's a situation like in People versus Bennett, where this court found that just getting bodily in someone's way and forming a human wall and stopping them from pursuing a pickpocket, that's a use of force that satisfies the force element of robbery. So there are many other permutations that could have supported the force element. And again, the court didn't have to elicit those. As long as the defendant didn't negate an element of robbery, the court didn't have to elicit any facts at all. And that was the Court of Appeals made that clear in People versus Goldstein, where it said we've upheld guilty pleas where there's absolutely no elicitation of the underlying facts of the crime, and that was fine. It's even clear in People versus Sieber, where there's a problem. The defendant is supposed to be allocating to a burglary, but she gives an account where the victim is a grandmother. She goes in the victim's house, presumably invited, and she's planning to commit a larceny, but she goes in there lawfully. So after a conference with her attorney, she says, she's asked, "Did you remain unlawfully?" "Yes." And the defendant was troubled and said nothing in her factual allocution, nothing in the facts you can glean from records support that. And the Court of Appeals says it didn't have to. If she didn't negate an element, there was no need to come up with what facts did happen. So even there are plenty. Yes, Your Honors.
Okay, thank you, Mr. Tarbin.
Thank you.
So, Ms. Watros, you get 1 minute in rebuttal.
Thank you, Your Honor. Where the court did choose to elicit these facts, even if the court didn't have to elicit those facts, and where he explicitly, repeatedly refused to agree to this thing, maybe he didn't see it. He could have said that what's important is that the court could have taken a question or two just to say, do you disagree with this case? As in Goldstein, where
do you agree that all of the court's questions and inquiries were not focused on his conduct, but rather were trying to get out of his plea allocution a statement against the co-defendant? They were trying to get him to implicate the co-defendant. Every time he refused to answer a question, the question regarded the co-defendant.
Yes, it was about the co-defendant because there were no allegations that my client had used or threatened a threat of force. It's not clear whether he was negating this because of some, allegiance to the co-defendant, or if he just didn't understand that use of force was required in this case. And it wouldn't have taken much for the court to just say, do you understand that an element of robbery is use of force? And you keep saying use of force didn't happen here. In Goldstein said that he didn't understand something and then said, but I don't dispute the veracity.
There was between counsel and the defendant at each juncture that he answered in the negative or refused to answer. Isn't that right?
Yes, but we don't know what they talked about. And there was nothing on the record that the court was able to confirm that he understood this charge. And that was the court's responsibility here.
Okay, thank you, Ms. Watros.
Thank you.
Thank you both. Palau versus Pagan.
May it please the court, my name is Meredith Nolan, and I'm with Lewis, Brisbois, Biscard, and Smith, and I represent the defendants, respondents in this case. I will be very brief as the appellant is not here
I would
today.
appreciate that. Usually difficult to argue against yourself when you have.
I understand that, Your Honor. I'll be very brief. I just wanted to point out that in this case, the evidence shows that the plaintiff violated the Vehicle and Traffic Law 1411 by making a left turn in front of the defendant's ambulance when the ambulance had the green light in the right of way. Even if the ambulance was double parked as the plaintiff claimed, the ambulance entered the intersection when it was safe to do so, and the plaintiff's vehicle cut in front of the ambulance at the last second, and there was nothing that the ambulance driver could have done to avoid the accident. I would also just point out that the plaintiff admitted that she heard the engine of the ambulance 5 to 6 seconds before the accident, yet she proceeded to go anyway.
Okay.
So
I think you have me a defendant had the right of way.
okay. Thank you so much, Your Honor.
Okay.
All right.
Thank you.
Have a good day.
You too.
Thank you.
Next case on the calendar, Board Managers, Peregrine Tower versus New York City, 2014.
Good afternoon, Your Honors. Michael Pontone, the law offices of Michael J.S. Pontone, Esquire, for Appellant NYC 2014 LLC. If it pleases the court, may I begin?
You may.
Thank you, Your Honor. Your Honor, my client is the defendant in a foreclosure action. As you're aware, we acknowledge that there are arrears owed in terms of common charges to the condominium. The main point of contention that has kept us from settling was that there were approximately $55,000 from a previously dismissed action that was included in the calculation of allegedly owed attorney's fees.
Yeah. I mean, I agree that, you know, the better practice would have been for the money for plaintiff to seek to collect the fees. There are right soon after the 2015 case was over, but they didn't. The underlying question for me is, didn't they have the right to that money pursuant to Article 5, Section 9 of the bylaws, which basically permits them to collect that money?
Of course, Your Honor. Your Honor, the 2015 action was ultimately dismissed. They were not successful in that. Was
there a requirement that they be the prevailing party? When I read Article 5, Section 9, it doesn't seem to indicate anything about prevailing party. I know that that's sort of the standard in getting these fees, but that's not how the bylaws read.
I understand, Your Honor, and respectfully, it seems that this is a very interesting question, I feel, to be in front of the appellate, because how does this prevent any board of condominiums from being completely abusive to its tenants if there's no sort of judicial review of the alleged funds that were owed? And indeed, at the trial level, the Honorable Judge August had referred it to the Honorable Judge Ramos, who then referred it back to Judge August to make a determination. However, as shown in the record, Judge August simply said, Judge Ramos says everything is owed. That is not what
had ECB not made a determination with respect to the violation of Administrative Code Section 28-210-3, which prohibited the use of a residential dwelling for transient occupancy, right?
Yes, Your Honor. The Office of Administrative Trials and Hearings had sustained one Department of Buildings summons for one instance where they alleged that there was the breach of that Department of Building code. However, the Supreme Court action from the 2015 action under index number 154935 of 2015, which again was dismissed without a conclusion as to the allegations, alleged multiple causes of action that were not far beyond the subject of the summons pled by the Department of Buildings.
But
this is Judge Scarpula, right? So all you need is one to prove your 2015 action, correct? You don't need to prove the plaintiff, the condominium pled them all. But once the ECB found a violation, there wasn't even any other purpose for that to continue on the lawsuit. Then the condo had its just cause to evict you. So if you're saying, well, they should have continued to litigate that litigation and rack up even more fees that my client would have been responsible for, is that really the position you want to take?
Well, Your Honor, it's not that because they were able to evict them just because they had one sustained instance. They didn't do an eviction action. We're here on a foreclosure action. This is an action for the failure to pay fees associated with common charges, which we acknowledge that we owe. There's never been any sort of housing court proceeding or standard that says the sustaining of a Department of Building summons somehow validates a petition. There was no petition at bar to evict.
No, wait a second. The first lawsuit, the lawsuit that you're objecting to the fees had to do with you running a transient, the apartment being an Airbnb or whatever you want to call it, a short-term rental, right?
Yes, Your Honor.
Then the ECB found that it was.
During the pendency of the 2015
during
act.
the pendency of that first proceeding, correct?
Correct, Your Honor. And that only said that there was one fine that was held.
But there's no, so what is what I say to you about that? If it was 100 or 1, what's the difference? They found that you had done it. And that was in violation of the proprietary lease, right?
That is what they're claiming. Yes, Your Honor.
So then they're entitled to, under the lease, they're entitled to fees for that, even though they didn't continue on and rack up more fees for it.
Respectfully, Your Honor, it creates a very arbitrary standard. They could have started 50 different lawsuits against the.
But they did. The fact is, they started one, and ECB really ratified their concern that you were misusing the apartment, right, or the condo unit.
Well, that there was one instance in one section. It's not a finding that it's.
All you need is one. It's like giving up a grand slam. All you need is that one hit, and it's over, right?
Respectfully, Your Honor, again, it appears that it's a fascinating question of law. It creates a weird in-between where there needs to be at least a hearing as to, in my opinion, respectfully, the propriety of the legal fees amount that were ultimately awarded. And the main thing there are two sections about the question of law and actually the procedure that went on at the trial level, where Judge August referred it to the Honorable Judge Ramos, who said Judge August has to ultimately rule on the exact amount owed, and then Judge August said Judge Ramos has ruled on what's owed. That's not what it is before us. There was no trial. Your Honors, quite literally, they could have just put another one in front of it. It could have been 1,130,000, and they would have rubber stamped it. There was no hearing. There was no finding of any fact as to the propriety of the award of the attorney's fees.
Wait a second. Didn't you have a hearing in front of Judge Ramos?
Judge Ramos just reviewed the no.
You were there, right? You could have said, no. This 3 hours wasn't charged on Tuesday at 3 o'clock.
Your Honor, he referred it back to Judge August. That's exact. There wasn't a determination made. He referred it back. I can read to you the exact words that were put down into the decision.
I thought he said the fees were reasonable.
He said two different things. Sorry, page 17, line 22. The special referee, the Honorable Charles D. Ramos, stated at this hearing that Judge August was the one who would determine the award and either accept or reject all of the so-ordered reports. During this hearing, the Honorable Charles D. Ramos reiterated the fact, quote, whether or not your client, the defendant, is responsible for legal fees going back to 2015 will require a determination by Judge August.
No, as to whether or not as a matter of law under the proprietary lease, but he found the fees were reasonable as stated. There was I went back and read that transcript too. He looked at the bills and he said the fees were reasonable. The question he's saying was going back to August was whether or not to include the 2015 fees? And August said, yes, include them. But not whether or not there was an overbilling, or that was not the issue.
I will admit there were Judge Ramos said two different things during the course of his transcript. At one point he said, yes, it's reasonable. I brought up, how is this reasonable? It's going to make a determination. Judge Ramos says that'll be for Judge August. So I acknowledge that there's an ambiguity, but there's clearly an ambiguity. I see if I can, any time left I have, I can allow.
Thank you, Mr. Banton. Let me hear from respondent.
Good afternoon, Your Honors. I'm Magda Cruz for the Board of Managers. Your Honors, the issue here is very, very narrow. Essentially, was the prior action fees properly included and assessed against this unit owner? There is absolutely no question that the purpose of the prior action was to enjoin this unit owner from engaging in an illegal transient use of the apartment. The question is, what is the condominium entitled to recover those fees? As Justice Acosta indicated, which I believe correctly, the bylaws of the condominium clearly entitles the board to recover those fees. My adversary contests that there has never been any hearing on that question, that it is a board can just decide to include any amount of legal fees for any kind of action, whether it's frivolous or not. That is a red herring, because in fact, there was an entire trial done by the City of New York before the ECB, in which the unit owner, and he had witnesses and his lawyer was presented evidence that in which he had a full and fair opportunity to challenge the illegal transient use.
And the ECB decision was issued during the pendency of the 2015 action, right?
That's correct.
So then you withdrew as a result of that.
That's right, Your Honor.
Sounds as if, what was suggested by my colleague, counsel wanted you to continue with that litigation and keep racking up fees.
There was no purpose for the action once the ECB ruled in that manner. I mean, it wasn't just a piece of paper. It was a full-blown evidentiary trial in which the unit owner had a full and complete opportunity to contest the charges.
Okay.
And essentially, both the court below, on summary judgment, evaluated that defense by the unit owner, that the charges were not appropriate. And on summary judgment, which is in the record, the lower court said, no, that defense is not valid. The bylaws entitle the Board of Managers to recover the fees for that violation because it is a violation of the bylaws.
And it has to be an appropriate legal proceeding, right? It's not just any proceeding.
That's right.
I mean, it has to be appropriate. You can't just make it up, as it was suggested.
It was suggested, but there's no factual basis for that claim, simply because the court dismissed, Judge Jaffe dismissed that prior action because no one needed to prosecute it anymore. But it was commenced correctly, and the fees that were charged for that commencement were found by the special referee to be reasonable. And that was sufficient. And for that reason, I respectfully request that this court affirm the lower court's decision properly based on the special referee's findings.
Thank you, Ms. Cruz. Mr. Pantone, you get 1 minute.
Thank you, Your Honor. Your Honor, respectfully, there is a conflation of the one ECB summons that is being conflated with the outcome of a Supreme Court matter with 5 different causes of action. The 2015 Supreme Court matter alleged declaration of illegal use, which arguably could have been alleged to be disposed of by the ECB. The second one is preliminary injunction. That was denied. Third one, permanent injunction. That was abandoned. Fourth one, fraud against the individual, Charles Sassetti. That was abandoned. And then the fifth cause of action was entitlement to the attorney's fees, which is no less, they claim at the time, of $75,000. Your Honor, respectfully, if they have completely abandoned all of their causes of action, for them to now say that, well, we got what we wanted from one summons, sustained in one instance by the Department of Buildings, it's revisionist history of the procedure of litigation history of the two parties. So, respectfully, Your Honor, I believe that they cannot rely on the bylaws to get every single dime that they've ever spent. And again, they could have put a 1 in front of that. There was no fighting. And
no, they couldn't have done that because it would not have been appropriate, right?
Respectfully, Your Honor, just one last thing. I was the one who was me personally, I was at all the individual arguments, including the one before Judge August and his court attorneys when we came back from Judge Ramos. There was still the question of how much was owed. They were looking at it as the appropriateness of the amounts owed. There was no hearing before Judge Ramos as to what was owed for what and the appropriateness of it. He switched it back to Judge August, who never did anything.
Okay. Thank you very much. Thank you, Mr. Pantone.
Thank you, Your Honors.
Thank you, Your Honors.
Very much.
Have a good day.
Inc. Berman.
Your Honor, Tom Brown on behalf of Israel Ingberman as Executor of the State of Helen Ingberman. May I proceed?
You may.
Thank you, Your Honor. This court should reverse the decision on appeal to avoid creating new law that overturns decades of precedent and makes no sense. The decision below imposes a level of formality and complexity for assigning an interest in an estate that is neither necessary nor justified. It does so relying on EPTL section 13-2.2, which has historically been treated as a recording statute and by its terms is a recording statute and has been interpreted for decades, including by this very lower court in 2015 as such a recording statute. And the intention of that statute is to protect assignees, future assignees, by letting them know that an assignment has occurred of an interest so that future assignees...
Can you tell me what the elements are suggesting that title remain in the estate?
Your Honor, when the mother died, and this case involves a mother and a brother and sister, and whether the mother died, her 2 children were appointed as executors. And the title of the interest was transferred into the name of the estate, and it has remained in the name of the estate because the estate is still open. It has not distributed out its assets, in large part due to this litigation.
So the question is whether Jeanette relinquished dominion and control of her interest in the estate, right?
Correct, Your Honor. The interest that she assigned was her interest, whether held directly or through the estate, in 4 hotels.
Right. So is that disputed? Because I didn't find. Go ahead. I'm sorry.
So the answer is that there's no dispute that what she assigned was an interest in the hotels that at the time of the assignment was held in the name of the estate. And the assignment itself specifically covers that eventuality. It says, I hereby transfer my interest, whether held directly or through the estate. And one of the problems with this decision, Your Honor, is that if it's upheld, then every estate has to be fully distributed to each and every beneficiary before that beneficiary can make an assignment. According to the court below, the only way to assign something while it's still held in the name of the estate is through a formal acknowledged document, which is then recorded. And this is brand new law. The lower court doesn't acknowledge it's making this law, and it doesn't give any reason for it. And what it risks doing is creating a whole slew of requirements for familial transfers like this one that are all of a sudden must have a certain level of formality, require lawyers in order to be done properly. And
also, the surrogate's court adhered to your understanding in her initial decision, correct?
so in her initial decision in 2015, she interpreted this section exactly as we believe it should have been interpreted and as the president would
There was an
dictate.
appeal, but it was not perfected, correct, of that decision?
Correct. The objectant filed an appeal, a notice of appeal and a statement, but did not actually perfect the appeal. So there's no dispute that the July 2015 decision is in fact the law of the case, and it holds what it holds, which is that this transfer could have happened through this instrument, notwithstanding the fact that it is not acknowledged and was not recorded. And there's no dispute about those facts. And historically, the failure to record might impact the validity of the assignment as to a future assignee, but it does not affect the validity of the assignment as between the assignor and the assignee, which is the situation we have here.
Judge Carpula, did you have a question?
I just wanted to ask you whether you're not saying that there isn't a question with respect to the assignment itself. There's a large question between the two parties, whether that's a forgery or whether she had capacity when she allegedly executed the assignment. You're just saying that the assignment doesn't have to comply with the statute because that statute concerns subsequent people who take for value, correct?
That's correct in part, Your
Okay.
Honor. The objectant has from the beginning, or had from the beginning, maintained that the instrument may not have been signed by Jeanette and may have been a forgery. However, during his deposition, when presented with the instrument, he acknowledged it was in fact her signature. So the question of—
But there's testimony from 5 other people who said she would never have done this. So that's the question, right? It's not like you're asking for summary judgment. You're saying I want a trial, correct?
Well, Your Honor, we're being a little greedy, perhaps. We're asking both for reversal and for an order that the assignment happened.
I think that's very greedy, particularly with everything that's been put in, which would, there's plenty of testimony going the other way. At the end of the day, you could lose not because of the statute, but because a court could find, as a matter of fact, that there wasn't a proper assignment as between the two of them.
Your Honor, you're correct. That certainly is a risk. However, we believe that the evidence, in fact, is that the people who didn't know about the assignment, in fact, didn't know anything about her finances generally, and that ultimately a court or a fact finder will determine the assignment was valid. But that's not in the record, and it's not before this court. The question before this court is the decision below, should it be affirmed or should it be overturned?
Okay. Well, let me hear from the respondent.
Thank you, Your Honor.
For the respondent, Francisco Colon, Mary Dorman, if it please the court, may it please the court begin?
You may, Ms. Dorman.
Your Honors, I disagree with my adversary's argument that the second decision, this decision being appealed by the lower court, held that an assignment of an interest in an estate can only be made pursuant to the formalities of the EPTL. She did not say that. She said the issue, which was framed by her and enumerated by each of us in our briefs for the second motion for summary judgment, was the issue of delivery of a gift. In the first decision, the judge said, yes, it's primarily a recording statute, but as between the assignor and the assignee, the one issue is going to be, was it a gift? Because the common law of gifts applies now. My adversary's position on this execution of the gift, inter vivos gift, which has to be completed to the point of no return during the donor's lifetime, was the tendering of this piece of paper, this assignment, which was unacknowledged, unnotarized, unwitnessed, just appeared from Israel, her brother.
So, Ms. Dorman, this is Judge Scarpula. Why can't I give a gift that way? Everyone, I can write to my brother, Joseph, here's $1 million, here you go. And it's in a writing. That's perfect. As between Joseph and me, there's no problem with that. That's a gift.
That is absolutely contrary to the well-established law of gifts, which has 3 elements. Donative intent, which the judge below said maybe this assignment might be evidence of donative intent, which we have always, never capitulated, ever. Number 2, delivery. The gift has to be given to the point of no return. If it's physically, if it's a car, you have to sign the transfer. You know, if it's depending on the character of the gift. That's what the law of gifts is about. Here, they've always said, well, just tendering this piece of paper, which was not revealed to anyone.
Ms. Dorman, this is Justice Moulton. I'm sorry to interrupt, but is there an issue of fact created by the letters? One is dated September 18th. They're both dated September 18th to the respective hotels saying, you know, you should start to pay Mr. Israel Ingberman. You know, so is that an additional, in addition to the assignment, which I agree to you is not much of a document to transfer so much money, but
millions and millions, Your Honor, millions.
But the letters, do they back up the possibility?
Thank you for bringing that up. They were executed a year before the assignment. The letters of instruction are signed by both executors. Jeanette remained an executor of her mother's estate until she died. So
was she still getting contributions from the LLCs?
Yes, she was, Judge. And the reason that I know that is not because they were produced in discovery. It's because I discovered them when the court permitted me to go through the files of Helen, the mother, her estate. And I located, going page by page through 8 feet of files, handwritten disbursement sheets, which appear in the record numbers 96 to 100. And here, after the date of the assignment, Israel continued to make equal distributions to himself and his sister. And I happened to come across that piece of evidence. This infuriated the surrogate. I would respectfully refer the court to the transcript of the oral argument before the second, the submission of the second motion. She requested that it be transcribed. It was submitted to her. And she said to Mr. Brown, as a matter of fact, what is going on here? Is this a lie? Is this a misrepresentation? Because in the first motion, Israel had submitted in his account that the hotels, the business entities that were held in the estate were never transferred out of the estate. But he submitted a sworn statement to surrogate court saying that they had been distributed, meaning that they had been taken out of the estate and given to Israel under the authority of both executors. And as a result, Israel owned them. That's what she believed, because that's what he submitted.
So they remain in the estate.
Yes, they do.
Jeanette continued to receive the distributions equally between her and her portion.
Absolutely.
And she never said, oh, I'm not entitled to that distribution in as much as I no longer own those assets.
Neither party, Israel or Jeanette, changed their position in regard to that piece of paper, the assignment. And that's all it did. Okay. And he hid it from everyone for 2.5 years. He did not bring it forward. He did not. Justice Moulton, in regard to those letters, he testified that that they were created for a personal bank loan. And there, Jeanette joined with him to instruct the manager of 2 of the business entities to deposit the money into an account under his name. Jeanette continued to receive distributions. That was not a transfer. And those letters are instructive because they show that both Israel and Jeanette knew how to make an instruction. And they could have said to the managers, please transfer the shares into Israel's name. But she would have never done that. I mean, there were a lot of witnesses for our side who said they were shocked that she would give away and disinherit her husband and partner of 30 years. Okay. And finally, just one more thing, that both parties agree on, that as Jeanette was dying, she was very ill. She had had a failed bone marrow transplant. She was in the hospital. My client, Mr. Colon, goes to visit, and Israel is in the room. Israel and Jeanette are talking. Jeanette turns to to my client, Mr. Colon, and says, I think I might give 10% of the hotels to Israel, at which point Israel quickly left because he had been caught. But in this, in his pleadings on in his brief, page 12, Israel concedes that this was the conversation, that the conversation took place. Why would they be having this conversation 2 years after the date of the assignment? Because
sounds like an interesting set of issues for trial. Let me hear from Mr. Brown. You muted, Mr. Brown. Mr. Brown, you are muted.
Thank you very much. I'll be brief. I think Ms. Dormer's presentation really highlights the factual issues that need to be resolved at trial in this case. And in my 2 minutes, I can't possibly go through point by point everything she said and refute it. But I will note that one point, Ms. Jeanette Ingram did tell her accountant she'd no longer be receiving K-1s, and she was the one who did her taxes. She recognized that she got K-1s when she had an interest in these entities. And her telling that to her accountant after signing the assignment, we believe is evidence that she knew what she'd done and intended to do it. And with that, unless the court has any questions, I'll end my presentation.
I think we're good. I'm sure Surrogate Mejia will have plenty.
Thank you, Your Honor.
Thank you both. Okay, JP Morgan Chase.
Yes, good afternoon, Your Honors. Louis Levithan of Nichols, Komasinski, and Manfro for Appellant Wilmington. As initial matter, it's respectfully submitted that the lower court erred when it dismissed this action due to the actions plaintiff took in attempting to comply with all court orders and the settlement of the long-form order granting judgment of foreclosure. There was, in fact, a judgment of foreclosure that was settled on notice to all named parties to the action and signed by the court. But thereafter, for really inexplicable reasons, it was never entered in the clerk's office. There was, in fact, a signed judgment. After that, East Fork did make a motion to dismiss for failure to timely settle an order. Judge McMahon heard that motion and sanctioned plaintiff $2,500, and then
she didn't believe it, right?
I'm sorry?
She didn't believe that there was a genuine attempt to settle the order she had ordered, right?
I don't know if she didn't believe there had been an attempt or if she was unaware of the fact that there had been a signed judgment in this case.
When counsel said that, it was misunderstood, what was her response? That's preposterous. Sounds like a little bit of skepticism, right?
Yes, that's as to after Judge McMahon's order, Judge Bluth, in dismissing the case, said that it was preposterous that plaintiff would then settle an order from Judge McMahon's short form order sanctioning plaintiff. It didn't take into account that there was, in fact, a prior long form judgment of foreclosure and sale.
But why wasn't the court advised of that when she specifically instructed that order be settled?
I understand. I'm unaware of why, and I don't think the record is clear as to why that wasn't brought up.
Yeah, the court was not happy with that, right? The court was like, it's incredible to me that the plaintiff did not immediately settle the order rather than wait until the end of the 30-day period to do so. When judges order things, they expect you to comply.
Of course, Your Honor, and I understand that completely. And I do think that there is established in the record a certain amount, as I argued in my briefs, of a law office failure that I submit is excusable in this case, especially considering the fact that there was no prejudice to any of the parties by the delay in this matter. Regarding some of the points raised by East Fork in its motion, it's respectfully submitted that East Fork is not a successor in interest to Peters, to the borrower's interest. East Fork took title to the premises through a foreclosure of a common charge lien. It took title through a referee's deed, not from Peters. And therefore, I submit that it's not that East Fork cannot assert defenses personal to Peters, namely that of personal jurisdiction.
But why did the court find that East Fork was a defendant's successor in interest?
Well, I believe the court held that he was not a successor in interest here, that the order of Judge Bluth said that he was not an interested party initially.
No, but in the January 2018 order, the court identified East Fork as quote unquote defendant successor in interest. So clearly the court thought that East Fork had standing.
It does say that in that order. However, the prior order of Judge Bluth had held that East Fork had no legitimate interest in the action. Be that as it may, Peters is no longer even a necessary party to this action. Should in any event no longer having title to the property. And Peters and East Fork cannot assert defenses that are personal to Peters, namely personal jurisdiction, and attempting to basically receive a windfall by asserting.
If East Fork was a defendant and successor in interest, as identified by the court without being corrected, doesn't that mean that East Fork does in fact have standing to seek dismissal of the action? They did, and that motion was granted. So
well,
what
they
are
may
we
have
talking about?
They may have standing as an interested party, they may have standing, but not as Peters' successor to assert lack of personal jurisdiction.
But that's not why the case was dismissed. It was not dismissed because of the failure, as you would concede, to not adhere to the 30-day limit set by Judge McMahon, correct?
Correct. But in addressing East Fork's arguments on their appeals, they also assert that it should have been dismissed both for lack of personal jurisdiction and also for failure to comply with 3215C, which I also assert is not the case, as the order granting default judgment in September of 2009 specifically held that the parties were all parties that did not appear or answer were held to be in default, and therefore 3215 dismissal would not be proper. The case law on these issues is clear in the fact that while East Fork may have an interest in the property pursuant to their deed, that interest was taken subject to plaintiff's mortgage. And because they took their interest when there was a valid LP on the property, a valid list pendant. And it appears to me that what East Fork is—
Counsel, this is Judge Scarpula. You're telling me that you don't think there's any prejudice with your client starting an action in 2009, someone else purchasing the deed in 2016, and between 2015 and 2000 and when the action was dismissed, your client doesn't do a single thing. So the property's tied up for years. The purchaser for value of the who purchased because of foreclosure on the lien can't take the property, can't sell the property, its money is tied up. You don't think any of that is prejudice? Because I have to say, I kind of do.
Your Honor, if there had been no list pendants filed on the property at the time East Fork purchased the property, I would agree with you.
Anytime you file a foreclosure action, any title search, any search of that property is going to bring up that. So you've tied up the property from 2009 when you brought that foreclosure action. And what about the years that the purchaser of the lien, the purchaser of the property under the lien has all its money tied up in the property? That's additional prejudice, right?
Your Honor, I don't believe it's prejudice when they bought the property knowing the facts and knowing that this was a foreclosure action pending on the property.
Well, what facts did they know? They knew the owner of the unit was not paying maintenance. That's what the underlying lawsuit was by the board, right? So the guy's locked up for life. So basically, they have the property now that they're getting foreclosure. And you don't do anything forever. So they now own a property on which I don't understand why you don't think that's prejudice. That's unbelievable to me.
Your Honor, they purchased the property with plaintiff's lease pendants in this foreclosure action filed. So they bought it subject to plaintiff's mortgage
So
into the ongoing
what?
And understanding that the timelines, I'm sorry,
Right.
Sally.
So what? They bought that in all the facts that you just recited. As an investor, lets me know that eventually I'm going to be able to finish buying the interest on this property and do something with it. They don't buy it just because they want to park their money somewhere.
Well, I believe they bought it here as a junior interest. Their lien was only junior. So if plaintiff had completed its foreclosure in a faster pace,
But it doesn't mean that they expect you not to obey court instructions to settle order timely. I mean, usually when you buy property and proceedings are governed by timelines and finality. It's not for you to sit on your dominant lien or your dominant interest in the property and forget about all of the legal requirements for you to proceed quickly.
Certainly,
and banks are not in the business of owning property. They're in the business of mortgaging it. So, and collecting on the debt.
Certainly,
so that argument falls on deaf ears.
Well, I certainly wish that this action had been moved at a more rapid pace, and that those the order had been settled quicker. But there was a long form judgment that was settled and signed, and then never entered in this matter.
Okay, let me hear from me. I'm sorry, Justice Capula.
It's 3 years later. So in January, the East Fork gets the deed, and you move in like June or April. So 2 months later, so they're thinking, okay, they're moving in 2 months. This is gonna resolve, and then nothing happens for 3 years. 3 years, right? That's the timeline, correct?
Right. The judgment was granted in 2017. That's correct. That's when the short form order was granted.
You moved they got their deed in January of 2016. You moved in April 2016. So they have East Fork has the reasonable expectation that in a couple of months, this is all going to be resolved. Either I'm going to get my money back because you're going to pay me or I'm going to pay the mortgage off, and this is all going to resolve. And nothing happens for 3 years, correct?
Well, no. After that, there was a decision in order, a short form order, granting judgment of foreclosure and sale on January 23rd, 2017.
That was that was not entered, correct?
Right, and then plaintiff settled the long form judgment, which was never entered. Correct, Your Honor.
So 3 years happens with nothing happening.
Okay, let me hear from. I'm sorry.
I'm just saying East Fork's money is tied up for 3 years. That's it. Huh.
Okay, let me hear from East Fork. You have Mr. Levithan, you got a couple of minutes in rebuttal.
Thank you.
Is East Fork on the line?
Good afternoon. This is Paula Miller for East Fork, the respondent. May it please the court.
Good afternoon, Ms. Miller. You may proceed.
I'm glad that the panel is recognizing the prejudice to East Fork and the delay, and the fact that the argument that East Fork made in the first motion to dismiss under 3215C appears to be coming to the forefront here. And I would ask the court to consider that because, yes, the prior owner who was not served correctly to begin with, but that's another issue. An attempt to take a default against that owner was taken within only a matter of months of the default. But then the plaintiff proceeded on a 7-year respite in an unopposed foreclosure action where nobody's raising any defenses. And they finally wake up after East Fork buys the property in 2016 and then goes for their judgment of default. Now, the plaintiff was aware that this was a condominium and should have suspected that the board may not have been so lackadaisical about enforcing their rights, and perhaps the board would have proceeded with their foreclosure, which ultimately they did do, and they sold it to this third party. So just addressing this length of a delay and the fact that the plaintiff did not seek its default judgment within a timely fashion, I'm very appreciative to see that the court is recognizing that. The order, the final.
We recognize it, Ms. Miller, but it doesn't mean that we think that you were entitled to seek vacatur based on 5015 and continue the litigation in behalf of Mr. Peters.
Well, I'm not sure if I misread Judge Manzanet's response to that, but perhaps I took it upon the fact that the MTGLQ Investors versus Shea case, which was just rendered in January of this year, which Justice Manzanet was the presiding justice on that case, was exactly the same fact pattern here. You can actually transpose that case onto the facts here. It was the same thing. It was an owner took title during the pendency of the foreclosure action. The court held they had standing to vacate the default of the prior owner, and to raise what plaintiff's counsel is calling a personal defense, but they were able to raise personal jurisdiction as a defense in that action, and they were able to raise the 3215C defense.
But the court, I mean, if you look at the Court of Appeals in Oppenheimer, right, it talks about an interested person in the context of, I mean, a couple of dozen words, right, including relieve a party. So the question is, are you a party?
Well, actually, Oppenheimer specifically says you do not need to be a party. It's any interested person may come in and vacate. And there's been cases, we have our brief is loaded with them under the 5015, that as long as you have a legitimate interest, and a legitimate interest has been determined to be an interest in the ownership and property. So if you have a legitimate interest in the property, which Eastfork certainly did, it was the owner of the property, it has the right to come in and to vacate the default of somebody who is a party to the action, somebody else. And that's exactly what the Shea case did. In Shea, this court held that just by virtue of the owner being an owner and having the equitable right of redemption, they had standing to come in and to oppose the entire foreclosure action and to raise all the defenses. Another recent case is the case out of the second department.
But can you continue to litigate in behalf of Mr. Peters when his interests already have been extinguished? In fact, the interest in the apartment you didn't get from Peters, you got from the board of managers itself, right?
Yes. However, when the title is acquired through a judicial proceeding, such as a sheriff's sale or a foreclosure sale, it is not necessary that the transfer be a direct transfer from the debtor to the purchaser. The process of that judicial sale renders the transfer, deems the transfer as coming from the debtor. So regardless of how Eastfork came into title, whether it be through a referee's deed, which is in fact the case, or whether it be Peters directly, those rights still carried over. There's no distinction. The case that we've cited, I believe, is the Gibbs case. It's in our papers. But again, I don't see how this case differs at all from very recent cases, such as Shea. Another case is Wells Fargo versus McKenzie out of the second department, where CPLR 1018 was the mechanism by which the court recognized the successor owner standing in the shoes of its predecessor and being able to raise all of those defenses, including 3215C. So,
but it doesn't mean, even based on Wells Fargo, it doesn't mean that you will be entitled. I don't know why I'm getting feedback. I don't have anything on. But it seems to me that it doesn't really matter, even if you have been adjudicated an interested party, you will still not be permitted to assert a defense of personal jurisdiction based on service to Mr. Peters, right?
Oh, absolutely we can, because as the successor, we stand in the shoes of Peters. We are treated as if
I thought personal jurisdiction, even based on that Wells Fargo case that you just cited from the second department, you're not allowed to assert as a third party. You cannot challenge personal jurisdiction of Mr. Peters.
Well, the cases say, and even coming out of this department, Judge, is that even the court can sua sponte dismiss a case for lack of personal jurisdiction. If the court knows that there is no personal jurisdiction, which the court here did know, the court said absolutely that this guy was serving a life sentence. This was not his dwelling place. Service was not good on the concierge. The court recognized service was no good. The court should have sua sponte dismissed this case and had the power to do that. That's Miller versus 21st Century. It's a First Department case.
But he didn't, right? Instead, he entertained your motion.
I'm sorry, Judge?
The judge did not grant your motion sua sponte, did it?
She did not, but she had the power to do so. I'm talking about the standing to raise the jurisdictional defense, even if Eastfork had no standing. And even if it just fell upon the ears by accident of the court, she could have sua sponte dismissed it without anybody bringing it to her attention.
I look at those cases, but it sounds to me like West Fargo stands for the proposition that you will not, that you as a third party, you will not be permitted to assert a defense of personal jurisdiction. No third party can challenge personal jurisdiction on behalf of one of the parties, but that's, you know, I'll look at that. We don't have to go back.
I just asked the court to please look at the recent case of MTGLQ versus Shea. It's January of 2021. Judge Manzaret is probably familiar with the case. It's exactly on point, and it does same acts.
If Justice Massenet decided it, then she's always right. So
yes, and I think she remembers it.
Let me hear from Mr. Levithan. You got a minute of rebuttal, and you're still muted, Mr. Levithan.
My apologies. Sorry, Your Honor. Yes. Eastfork cannot dispute the fact that they took title to the property, knowing of the list penance and knowing of plaintiff's foreclosure, and that there had.
I don't think they disputed that, but that's my fight with them. The question that I have for you is, they also not in they. There's an expectation that you're going to proceed swiftly and legally, right? If there are timelines, like, for example, an order of the court to settle a particular order, that you are required to do that. That's not something that you just allow, oh, you know, I can do whatever I want and take however long I want, given Eastfork's interest, right?
Right. And then after Eastfork took their interest, the judgment was filed, and then the judgment was granted, and then there was the unfortunate issues that occurred between the time of the granting and the short form order, the settlement of the long form order, which was signed and then never entered, and then this unfortunate settlement of the incorrect order after Judge McMahon's order sanctioning plaintiff and then directing the settlement of the order. As far as the ability of Eastfork to assert the personal jurisdiction of Peters, as Your Honor points out, that's a defense that's personal to Mr. Peters. And in any event, at this juncture, Mr. Peters isn't an indispensable party to this action. He no longer has an interest in the premises, and unless plaintiff was to seek a deficiency judgment against him, he can be dropped from the action. So therefore, even if the action was to be dismissed against Mr. Peters, it could still continue against the other parties, and Eastfork would still be subject to the outcome of those proceedings as it has a junior lien in the premises.
Okay, thank you, Mr. Levithan. Ms. Miller, you are cross appellant, so I'll give you a minute.
Yes, and I'd just like to address the third order, which clearly should be affirmed, because again, it was a conditional order. It was a preordained consequence that if it was not complied with, the case was going to be dismissed. To try to bring up in their brief the good cause or attempts at good cause now at this juncture is just not the place. Judge Bluth's hands were tied at that point, and really the interim order, the second order by Judge McMahon, who, as you indicated, already determined that Eastfork was a successor defendant and had standing. that really ruled the day, and there was really no way around that once they didn't comply.
And Ms. Miller, that was the order that contained the 30-day time limit, correct?
That is correct.
We're talking about the January 30th, 2018 order.
Yes, that was a conditional order that triggered a default once there was lack of compliance.
Right.
Okay. Great. Thank you, Ms. Miller.
Thank you.
Thank you, Mr. Levitan.
Thank you, Your Honor.
Next case on the calendar is New Canaan versus Chabon Park.
Good afternoon, Your Honors. Michael Gordon, Gordon Law LLP for Plaintiff Appellant New Canaan Capital Management. May I proceed?
You may.
Thank you, Your Honor. There are three issues presented by this case. The first is the question of whether or not the fraud claim was duplicative of a malpractice claim and therefore governed by the 3-year statute as opposed to the 6-year statute. And the two other claims, the two other issues relate to defense of res judicata. I'd like to begin, if I might, with the timeliness issue, the duplication issue, because within the last 3 weeks, this court has issued 2 decisions that make it abundantly clear that where, as in this case, you have intentional misconduct, intentional fraud by a lawyer, then that is a standalone fraud claim, even though, since it is a fraud on a client, it subsumes necessarily malpractice. Every time you have a fraud by a lawyer against a client, you're going to have malpractice. But the reverse is not true, or the converse is not necessarily true. And the 2 cases which I sent to the court earlier this week.
No, I mean, I saw Bosky. I thought that Bosky case significantly different than the underlying facts in this case. I mean, what I would like you to do, Mr. Gordon, if you can, is to distinguish to me the malpractice versus the fraud, because it sounds to me like they one and the same. As it was previously characterized, essentially legal malpractice claim in a different garb. So can you address that?
Yes, Your Honor. So it would be malpractice if the issue were whether or not Chadbourne and Park simply had a conflict of interest, or if they had covered up the conflict of interest. But instead, what we have here, as in the Bosky case and the Wimbledon case and the cases that preceded it, Berman against Holland and Knight and Johnson against Proskauer Rose, you have in this case lawyers actually drafting documents, editing documents, taking affirmative steps to disenfranchise, to basically de-equitize my client. And the way that was done was the Chadbourne lawyers drafted, without my client's knowledge, they were drafting modifications to agreements that essentially changed the waterfall of proceeds that would come out of this deal, with the result being that at the end of the day, my client, instead of having a 20% interest, my client now has nothing, 0. And that wasn't the result of bad lawyering or neglect. It was the result of affirmative acts of misconduct, affirmative drafting, which we cited in the complaint. We actually cut and pasted and put into the complaint itself the emails that had been discovered in another action that confirm the very acts of misconduct done by the Chadbourne lawyers.
Well,
so
which acts are those? The conflicts itself?
So it's not just the conflict, Your Honor. It would be the conflict as well as the affirmative drafting of there was a letter agreement. There were emails that were sent to my client advising the client that it was okay to go ahead and sign these agreements, which is really no different than what happens in these tax shelter cases, such as Bosky, which and that involved the Herrick firm, which interestingly enough, the Boesky case was decided in the lower court by Justice Branston, who had issued the original decision in this case. And so that's really the distinction. And I think in Boesky, this court, or maybe I guess it would be more in the Wimbledon case decided on March 25th, where this court sort of brought the issue to a head in very clear language and said that the essence of the claim is not negligence or failure to utilize reasonable care, rather plaintiff alleges intentional acts. And that's indisputable. With respect to the two res judicata arguments.
Intentional acts, I'm sorry, Mr. Gordon, intentional acts that relate to the representation itself, no?
Well, intentional acts that actually are purported to be in the interest of the client, but actually we're working for the other side. We're working for the competition.
So that's the conflict, right? Why isn't that malpractice?
Well, it is malpractice, but malpractice subsumed within fraud. If what the Chadbourne lawyers did here doesn't constitute fraud, then essentially no case by a lawyer, no act of treachery by a lawyer would ever constitute fraud. And clearly that's not, I mean, this court has made clear over and over that that is not the law. With respect to the res judicata arguments, I would just say on the issue, I'm sorry, on the issue.
This is Judge Scarpula. I mean, conflict of interest is a malpractice issue. It's not a fraud issue. And what you've pled here is conflict of interest, correct? Other than the conflict, have you pled anything else that would support fraud?
Yes, I believe so, Your Honor.
Which is what? That's, I think Judge Acosta asked that. I didn't get it. I'm going to ask you again.
Yes. So the fraudulent conduct was drafting documents and presenting them to the client and presenting them as being in the best interest of the client, when in fact they were actually contrary to the interest of the client. It's no different.
You're saying they're helpful to the other clients, for which that creates a conflict of interest. I mean, you can work around those words, right? But what you're describing, I can call my screen a duck, but it's still a screen no matter what I call it, right? So what you're describing is a conflict, even though you're calling it fraud. So I'm just going to ask you one more time. Is there anything else aside from that the drafting of the documents and that gave their alleged other client a better shot or a better deal? Is there anything other than that you've alleged?
Well, it's the drafting of the documents and the presentation of those documents to the client as being in the best interest of the client. No different than in the Johnson case, when the accountant presented a tax plan to the employee and said, this is how you should file your taxes, knowing that that was hurting the putative client. Same thing.
Underlying facts that are very different than in Boesky I sat in Boesky, and the facts are, and the conduct itself, the nature of the conduct is different, right?
So I really don't think so, Your Honor, with all due respect. I think the difference is the nature of the transaction, but essentially you have the same, you had a conflict in Boesky too. You had a conflict in Wimbledon and these other cases. It's always going to be present. The question is whether the claim involves affirmative intentional misconduct, as this court noted, or not.
Okay, let me hear from respondent.
Thank you. Robert Schwinger from Norton Rose Fulbright for the attorney defendants. I think as the court correctly noted, what really comes down to here is what's the plaintiff's theory of injury? And the plaintiff's theory of injury is that it was deprived of the interest it expected to get in this project when it signed this agreement in January 2014, and that the lawyers said that it was okay to sign the agreement, but they were laboring under a conflict of interest. And there is no suggestion here of affirmative misrepresentations of fact that are independent of or subsequent to his professional services. Rather, it literally concerns the advice given as a part of and in the course of the services. This is completely different from a case like Boski or Johnson or Berman versus Howell and Knight, where the lawyers are running a tax shelter mill and they're in bed with the promoters. That's not the facts here. The Wimbledon case and also the Schlissel versus Subramanian case that the plaintiffs rely on, the lawyers are involved in fabricating documents and falsifying documents, backdating documents. There's nothing like that going on here. By definition, in a conflict of interest.
Counsel, this case may be time barred, but it's not like the law firm here represented the plaintiffs here in the way that they should have been represented. So, I mean, they're not the exact same facts as the other cases, but it's not like your client comes to this court with completely clean hands here.
Your Honor, understanding that we're taking the allegations of the complaint, assuming that they're true, the remedy for that situation is a malpractice claim to be brought in a timely fashion.
I started by saying that. My point is, you're not coming here lily white without a stain on you.
I understand
let's not pretend like that's not the case.
I understand the picture that's painted in the complaint, Your Honor, but that doesn't determine the issues which are now presented on this appeal.
Okay, Mr. Stringer, was Judge Branston's dismissal of 2018 on the merits?
Yes, it was. It was dismissed on the basis of the statute of limitations, which is a merits dismissal. And I want to make an important point here, because the plaintiff keeps saying, well, I could have repled and fixed the problem, so therefore it was a mere pleading deficiency. Most fundamentally, we did not move to dismiss for failure to state a claim. We didn't move under 3211A7. We moved under 214 sub 6 and under 3211A5 purely on the statute of limitations. So plaintiff is essentially trying to hypothesize a different motion that perhaps we could have made, and then treat Justice Branston as if she had ruled on that hypothetical motion, and is saying, now let's substitute all that for what actually happened in the lower court proceedings and pretend that that's what happened. But that's not what happens.
Okay. Okay. Thank you, Mr. Stringer.
Thank you.
Mr. Gordon, you get
Your Honor, I am for the non-attorney respondents. This is
I'm sorry. I'm so sorry.
I know I'm not that important.
You get 4 minutes.
I don't think I'm going to need 4 minutes, Your Honor. I think the record speaks for itself, but may it please the court, this is Alan Heller from the firm of Forster Garvey for the non-attorney defendants who have been dragged into this malpractice dispute. May I begin?
You may.
Okay, so just quickly, because I don't need to waste any more time for this court, but it was a prior decision, a dismissal on the merits by the federal court. It was a claim for breach of contract. Those are precisely the transactions that are at issue in the malpractice and alleged fraud claim. Then my clients are dragged in once again after procuring a dismissal on the merits in a claim as alleged aiders and abettors of some sort of conspiracy to commit fraud. Res judicata, same transaction, same facts. It's just a regurgitation. My client should obviously not have to relitigate a dispute that's already been litigated. Mr. Gordon does try to allege that the fraud claims were discovered after the fact, but I think that's belied by the record. We mentioned in our briefs, but he does state in an affidavit, if you want, I could tell you the exact page number of the record, but he does state that they discovered the fraud for the first time in documents produced for the first time in 2017. That's a year before the federal case was dismissed. Also, there was a first claim against the attorney respondents that was filed 3 months before the dismissal in federal court. And in that complaint, there's a paragraph that specifically states or discusses the alleged fraud by the attorney respondents. So they had every opportunity to drag my clients in once again prior to the dismissal of the case in the federal court, and they didn't. Also, one case that's cited in Mr. Gordon's brief, it's the Spectrus case. That is Delaware law. It's not New York law. Delaware law on res judicata is a lot more stringent than New York law. New York law is a transactional test. You can't just redoctor a complaint under New York and call it something else just to try to bring my clients in again. And also, by the way,
but in any event, I mean, will collateral estoppel apply? I mean, the issues were the same. Plaintiff had a full and fair opportunity to litigate the issue, right?
Yes, and in fact, the judge. Tomato, exactly. Judge Gardafi, he gave him every opportunity to come in with a new lawyer. He gave him more than 8 months, kept warning him, and then finally just dismissed it pursuant to 41B, which is a dismissal on the merits. Judge Gardafi could have said it's a non-meritorious dismissal, but he specifically allowed it to be dismissed on the merits. So sorry, you didn't pursue your claim. It's done. Don't drag us back in. Finally, even if Your Honor should not agree with the lower court on that ground, upon dismissal of the case against the attorney respondents, this is an aiding and abetting or conspiracy claim. There's no underlying tort. There's no claim against my clients.
Okay, thank you, Mr. Heller. Okay, now we get to hear back from Mr. Gordon.
Thank you, Your Honor. First, with respect to res judicata defense by the attorney defendants, Justice Branston was not even close to making clear that this was a dismissal with prejudice. And of course, under 5013, it needs to be clear that it's a dismissal with prejudice. She said, I think you have to start a new action. She said, I'm dismissing it without comment. Okay, I'm not dismissing it with prejudice or without prejudice. And then she said about a week later, one thing we know is that you're still in it. So I think what she was doing there quite clearly was and I remember the arguments, was making clear that if we wanted to replead and address the issue of the duplication of fraud and malpractice, we could. She thought we would have a problem with the credibility of a subsequent complaint, but she nonetheless made it crystal clear that we could nonetheless proceed.
She did say that there was no magic word required, right?
Well, and that's correct. There are no magic words, except when you have a judge giving you the green light to commence a new action.
Although she did say plainly a dismissal on the merits. So I understand it wasn't as unequivocal as we would like, but nevertheless.
So and then ultimately, I do believe that what she was doing was dismissing it because, as pled, she saw a duplication of the fraud and the malpractice. And with respect to the non-attorney defendants, the Lukowski case, which we cited, says that even when you have two successive actions arising from an identical course of conduct, the second may not be barred if the requisite elements of proof and evidence are different. And that's what we have here. The first case, the federal case, was a breach of contract case, had nothing to do with fraud by lawyers, never raised. And the question is, for res judicata purposes, was it raised, was it, and then subsequently dismissed with prejudice? That claim, the claim that we're presenting, I would respectfully submit, was not raised and therefore could not have been dismissed in the original federal court action.
Okay, thank you, Mr. Gordon.
Thank you, Your Honor.
Thank you, Mr. Heller. Thank you, Mr. Schwinger.
Thank you, Your Honor.
JG Jewelry versus Sri Ram Krishna.
Good afternoon, Your Honors. May it please the court. Joshua Feinstein for the appellants. I'm going to turn to the service issue, the service under the Hague issue first. At bottom, this issue is about the maintenance of predictable norms and expectations in international litigation. And it's about reciprocity and cooperation among trading partners. If we expect foreign courts to consider the expectations and interests of U.S. litigants, we have to do likewise for foreign litigants. Likewise, we cannot simply override unambiguous treaty obligations in the name of convenience and expediency. India requires service through the central authority under the Hague Convention.
So this is Judge Scarpula. I mean, this plaintiff tried to serve you through the Indian authorities several times. Your clients left the premises, they wouldn't accept service. They did everything they possibly could to avoid service, under which the plaintiff tried to do under the Hague Convention, right? So now you're saying to us, but uphold the Hague Convention, even though the requirements of the Hague Convention, even though my clients made it virtually impossible for the plaintiffs to sue them.
Respectfully, Your Honor, respectfully, that's not what the record shows. The record shows that the plaintiffs made a very perfunctory effort to serve under the Hague Convention. They went through a Miami intermediary that delivered papers to the central authority in India. The central authority, without the assistance of the plaintiffs, it's true, made multiple attempts.
Attempts. And your clients left, one time they left the premises without giving a new address, correct?
It's not that they didn't give a new address. This is a large corporation. They have about $1 billion in sales. They're not like some fly-by-night operation.
Well, then why is it so hard to serve them, counsel? If it's $1 billion corporation, why was it so hard to serve them?
Because the plaintiffs gave the central authority the wrong address and then made no effort, had no communications with the central authority and correct that.
I think that the judge asked you on the record what the addresses were, correct? You remember that? I read it in the record. And at least one of the addresses that you gave on the record was the address that plaintiff was trying to serve at, correct?
That was approximately a year after the service attempt.
No doubt. You still haven't answered. If you've got the right address and you're trying to serve under the Hague Convention, you've done everything you're required to do under the Hague Convention, why is it so hard to serve your client?
But they did not have the right address. They gave the central authority the wrong address, and they made no effort to correct it.
But even when they went back and corrected it, they still couldn't serve your client through the service.
I don't believe the record, Your Honor. I don't think there was any effort to correct the address of SRK.
What about the personal attempts at the Hong Kong trade fair?
That's not. India has made very clear that the correct way of serving Indian litigants, Indian corporations, is through the central authority. Hong Kong has absolutely no connection to this dispute. It's the Indian rules that apply. These defendants are present in India, not in Hong Kong. Therefore, the state of destination was India, not Hong Kong.
Well, wait a second. Aren't their principal place of business Mumbai?
Yes, India.
Right. So that's, but I'm sorry. Don't they have business offices in New York?
Not my clients. I mean, there is an allegation that they put up a sign in the plaintiff's office at one point indicating that was their offices, but they never had a permanent presence. There's
so they didn't really mean it. It was their offices, but they didn't really mean it.
And
that is not enough for general jurisdiction, and the business.
But minimal contacts. I mean, if you look at 301A1, you clearly avail yourself of a lot of New York activities.
Respectfully, Your Honor, respectfully.
I know what respectfully means, counsel. So
Well,
you keep saying that, but you're just not coming up with straight answers to the
No,
question.
I'm giving you a straight answer, and the straight answer is there were contacts in New York. We don't deny that there were contacts in New York, but they were not substantially related to the plaintiff's claims. The plaintiff's claims here have to do with our alleged failure to contribute assets and profits to a Singapore entity operating out of India.
But even defendants' own affidavits show business transacted in New York, doesn't it?
We're not denying we have business transacted in New York, but it's not the claims does not arise out of that business. You know, a lot of the business they're alleging has nothing to do with the alleged joint venture. We have our own customers that had nothing to do with the joint venture. The question is whether this is specific jurisdiction, obviously, and the question is whether the claims arise out of our contacts in New York. And if you look at the record here, their allegations, their claims are all about our failures to contribute profits and assets to a Singapore entity operating out of India. It was negotiated in
Right.
India.
So the question is whether you have project yourself into New York to engage in sustained and substantial transactions of business. Clearly you have, right?
Respectfully, not with the business that our projection does not have to do with the claims. The fact that we do, if we're a multinational, if we may be doing a lot of business in New York, doesn't mean you can sue us constantly in New York. The claims have to arise out of the relevant context, and respectfully, that the record does not show that.
Okay, let me hear from Cross Appellant.
Thank you, Your Honor. Gregory Fleisler from Moses and Singer. May it please the court.
Good afternoon, Mr. Fleisler.
Good afternoon.
Pick up that thread about whether long-arm jurisdiction would apply here. Wasn't it the case that SRK and Jewelry both sent employees to work in New York with JDM?
Absolutely, Your Honor.
And they had a local agent in New York City, TLJ, or TJC, pardon me.
Yes, Your Honor. It's TJC, which stands for the Jewelry Company, which is one of the defendants in India. They had set up shop.
I'm sorry, that work was specific to the joint venture, was it not?
Absolutely. They had set up shop within our clients' offices in New York. They had sent their employees here for 1 week out of every 6. They were on the phone with their head office every day to find out what to be doing. With respect to the approximately—
And they were shipping jewelry back and forth between India and New York, both through the office and directly to clients.
Correct. And that's how, Your Honors, on this motion to dismiss before any discovery, we were able to attach hundreds of pages of shipping invoices that defendants sent to our office in New York with goods to be delivered on to clients in New York. The evidence here is overwhelming. Justice Cohen did a very thorough and well-reasoned opinion that conclusively establishes both that the service was proper in Hong Kong, as well as that there is jurisdiction here under A1. He didn't even need to reach 2 and 3, but there's jurisdiction under those prongs as well. There's just no question whatsoever. Your Honor's obviously a very strong command of the briefs and the facts. If there are further questions that I can answer for you, I'd be happy to.
Well, I don't understand how you can say there was service in Hong Kong. That's not permitted by India under the Hague Convention, right?
No, that's not correct at all, Your Honor. Defendants argue here that service upon an Indian corporation can only be completed through the Indian Central Authority within India, and that no service can be effectuated anywhere else in the world. That's absolutely false. If defendants were standing, let's pretend we're all together, if defendants were standing in this courtroom, under their own theory, we couldn't serve them with process. It's just wrong.
I think that's exactly right. I think if you stood in Ireland and I handed you a piece of paper, we would not in the United States consider that good service. The service internationally has to be done under the Hague Convention. I don't think there's that's there's any dispute over that, or maybe you do, but I think we've said it. The Court of Appeals in New York has said it, that the Hague Convention is mandatory.
Absolutely, it's mandatory, Your Honor. Wait, I think there's a misunderstanding here.
Oh, so what are you saying? Oh,
So-
you're saying it only can be done by the central authority.
That's what they're saying, that it
I
can
say,
only
and
be
you're
done by the
saying,
central
no,
authority.
I can do it. So
Correct.
what provision under the Hague do you think that under India's signatory part to the Hague, do you think you can serve in Hong Kong?
So it's Article 10, Your Honor, that entitles any signatory nation.
I know, but everybody's got their little dings to Article 10. So what are you saying?
We're saying that the state of destination is the state, is the country where service is effectuated. So just like if the Indian defendants were standing here in the courtroom, we actually are entitled to serve them with process. The same way we can serve them with process within Hong Kong. That's pursuant to the Hague. India has never said, it's never objected to all service outside of their borders and not through the central authority is improper. That's absolutely incorrect. I'm sorry.
Well, haven't we said that the destination state is the state of incorporation of the foreign corporation? That's what we've said. And the First Amendment said it in mutual benefits offshore funds, right?
No, it did not. It did not say that the country where defendant is served is the state of incorporation. And in
No,
fact,
the destination state is the state of incorporation.
no, the destination state is the state where the process is delivered, Your Honor. There's actually no case that says that a corporation can only be served in its country of incorporation. Beyond, sorry, Your Honor.
No, I didn't mean to interrupt. I thought you were done.
Okay, so beyond that point, which I think is made extremely clearly, both in Justice Cohen's decision and in the briefs. Secondarily, we took a cross appeal because the court rightfully found that service in India through the central authority was impracticable. And as a result, the court had also authorized alternate service, which we effectuated the very next day via 5 different means, via service by email, via service by registered regular mail, all of which was completed and documented. And that's an additional basis, not a substitute basis, but an additional basis that service was proper.
Counsel, what do you say to defendant's argument that you gave the central authority, the reason why you couldn't serve is because you gave the wrong addresses, and therefore it's really all on you?
That's absolutely incorrect. So we tried to serve in India via the central authority 4 times, Your Honor. All 4 of the times on defendant, the jewelry company, were on the exact same address, as Your Honor pointed out in the beginning, at the exact same address that they gave to us again in court before Justice Cohen. It was still unable to be completed. The other address was the address that they were using contemporaneously on their own filings in current litigation, on their summons, answering letters, located on their website. And at that one, you know, as you noted, the door is locked, they've left for the day, we've moved, nobody's here and available. So the court below, which oversaw the entire thing, found in its order that we made extraordinary 4 times. And each attempt, by the way, each set of attempts takes 6 to 9 months to effectuate. And we tried 4 times, and he found that we went to extraordinary good faith measures in order to effectuate the service.
I think we're good, Mr. Fressler.
Thank you very much, Your Honors.
Okay. You got a minute in rebuttal?
Sure. Again, I would urge the court to review the record for itself. I'm not aware that we provided the wrong address below. I'm only aware that we provided the correct address, and that was requested well after the service attempts. I'm only aware, the only thing reflected in the record is the initial application to the Hague Convention. Any other attempts were undertaken by the central authority. There's nothing in the record reflecting that the plaintiffs made any attempt to assist the central authority. And I do not believe that they've shown diligence. I think Justice Scott Paula is absolutely correct that there's absolutely no authority that you can serve an Indian corporation consistent with The Hague and Hong Kong. We're not claiming that there may not be some other circumstances where you might be able to serve an Indian corporation elsewhere, but here it's not the case. There's absolutely no connection between this case and Hong Kong, and they've cited absolutely no authority, and the court below did not identify any authority to justify this service. So again, they have not obtained service under the Hague Convention. We dispute vigorously that they have jurisdiction over the defendants. This is about a transaction that it was negotiated in India, it was performed in India, and any contacts that my clients have with New York are either totally irrelevant
Can you address the employees to New York in JDM's offices?
Sure. There were
the local agent.
Okay, local agent. There's two things. There's highly conclusory allegations that they were agents. They don't have any evidence of that, and there's no allegations at all that the so-called local agent was in any way involved with the formation of the joint venture and what's actually being at issue here, which is our alleged failure to contribute our profits and assets.
Okay, thank you, Mr. Feinstein. Mr. Fressler, I think you get 1 minute on your cross appeal.
Certainly. Just to correct a couple of misstatements that were just made, there are 4 affidavits of service from the Indian Central Authority within the record. The business that defendants conducted specifically in conjunction with the joint venture through our office began in April 2015 and concluded at the end of August 7th, 2017. It's well documented with hundreds of pages in the record as well. Many of those are located between, I believe, 213 and about 400 of the record sites. And the court found that service via The Hague in India was impracticable. That finding was never appealed. That order was never appealed. That issue is not on appeal, so it's still impracticable. And finally, with respect to the state of destination, I believe, through all the cases, particularly Greenberg and Interlink, show that it's the location where process is served. And to show, I think, the underlying fault in defendants' argument here is their position that no Indian corporation can be served anywhere in the world other than through the Indian Central Authority within India is just demonstrably false, because we know that if their officers and directors were coming through New York and were standing here, that you could serve them with process. And all the low affirmation and Order 65, Rule 3 from Hong Kong show the same thing in Hong Kong via The Hague. Thank you, Your Honors.
Thank you. Thank you both.
Thank you.
People versus Alvarez.
Good afternoon, Your Honors. Cami Lizarraga from the Office of the Appellate Defender on behalf of Bianca Alvarez. In this case, the prosecution accrued 247 days, or 8 months, of chargeable delay before Ms. Alvarez finally was tried on the felony charge. She was acquitted of that felony.
Can you tell me when was the first time that the people answered ready after the grand jury presentation?
Yes, they first answered ready on October 1st of 2014, which was approximately 5 months after the Ms. Alvarez was arraigned on the indictment. So that was an 150-day period pre-indictment, and this court has held that delays.
So wait, her Supreme Court arraignment was when?
Her Supreme Court arraignment was on May 4, 2014.
Okay, and at that Supreme Court arraignment, did the people answer ready?
No, Your Honor, they didn't answer ready until for the very first time on October 1st, 2014 was the first time that they answered ready, which was 5 months later.
So from the time of this defendant's arrest until Until October 1st of 2014, the people had not answered ready that entire time.
That's correct. So that was an accrual of 150 days of delay, or nearly 5 months. And the court below correctly charged the second half of that period, but it excluded the first 93 days of that period, on the ground that the prosecution was unable to proceed with its case without Mrs. Lawson due to her injuries, because that's what the prosecution represented to the court. But that was not the case, as the trial eventually showed. What the trial showed was that Mrs. Lawson did not remember the accident or its aftermath, and that she said that from the very day of the accident. So the prosecutor knew from day one that Mrs. Lawson remembered nothing.
But counsel, the felony count would have required the enhancement of a very serious personal injury. So couldn't she have testified to that? Or was there another means to get that before the grand jury?
There was another means, Your Honor. They could have called a physician on that element, which is the sole element to distinguish the felony. And that's actually what they did at trial. They called a physician who testified to the gravity of her injury and what the permanent impacts would be. And especially for this 93-day period that's at issue before indictment, the doctor would have known at least as well as Mrs. Lawson what the protracted nature of the injuries would be, and could have put that information before the grand jury, especially based on the lower reasonable cause burden that applies at that point in the case. So because
we agree with you about the 93 days, then, counsel, what about, you still need to get to over 184, correct?
That's correct, Your Honor. So in addition, yes, in addition to the 93 days, the court also erred in excluding an 83-day period that was post-readiness, in which it held that the people's state of readiness was irrelevant where counsel was unavailable. It there applied the without counsel exclusion, but it did so incorrectly for two reasons. First of all, the Court of Appeals has held that the without counsel exclusion applies when a person has no attorney. And in this case, it is undisputed that Ms. Alvarez did have an attorney. So that exclusion does not apply. Rouse considered a situation where the person was appointed counsel actually at the end of the court appearance, and it held because the person had counsel during the adjournment period requested by the people, the without counsel exclusion did not apply. So it did not apply.
Judge Scarpula, the counsel who was there was not the defendant's counsel. It was someone else, correct? From the same legal. She was
another attorney.
She had never entered an appearance or she didn't represent that she was the defendant's counsel, correct?
Well, she appeared on behalf of Ms. Alvarez from Bronx Defenders, who was the assigned counsel. You're right that she was not lead counsel, but she did not give any indication that she was not ready to proceed. She never said that. And in that way, this case is actually like Nunez, in which this court considered a similar situation in which a different legal aid attorney appeared at the appearance, and the prosecution attempted to invoke the without counsel exclusion, and this court held that it did not apply under those facts.
But counsel, the prosecutor said, and then the court echoed this, that, oh, the counsel of record is on trial. And the person who did appear from Bronx Defenders did not correct that or say, yes, she's on trial or he's on trial, but I'm ready to go. So that was an opportunity for them to say something at that point, and they didn't.
That's true that that defense counsel did not say anything, but that's also kind of the point. If the court thought there was an issue here, it's the prosecutor's obligation to make the record clear as to readiness. So, and notably, the prosecutor had not been ready at the two preceding appearances. Yet at this appearance, it didn't say, I'm ready for trial.
Say that again.
The prosecutor had not been ready at the two preceding appearances. So at this appearance, it could have said, we're ready, and that would have made the record clear and avoided this issue. It also could have said,
counsel, following this appearance, this adjournment that we're talking about that's in dispute, did the people ever file a statement of readiness with the court indicating their readiness to go forward with trial?
At the very next appearance, the prosecutor found it necessary to state it was ready. So that undercuts the...
And what date was that next appearance?
September 29 of 2015. So that undercuts the respondent's claim that because the prosecution had originally stated ready, that it no longer had the obligation to do so. Having stated not ready at the 2 preceding appearances, it had the obligation to make the record clear, as this court has held in Cortez. But instead of doing that, it attempted to say our readiness is moot because trial counsel is on trial, yet there was an attorney present in the courtroom. The DA or the court easily could have said, do you request this adjournment? Do you consent to this adjournment? If they had any understanding as to what lead counsel's position was, they could have put it on the record. And most importantly, the prosecutor could have said, we're ready to go. So this was a completely avoidable situation, and both delay periods are chargeable to the prosecution.
By counsel, by the same token, right? That lawyer who was in the courtroom could have said, I'm ready. There is a lawyer here. I mean, when the prosecutor said it and
whose obligation is it to be ready, counsel?
It's the prosecutor's obligation to be ready. That's what 3030 is about. And the Court of Appeals has actually held that defense counsel's failure to object or silence does not constitute a request or consent.
Okay.
It's the prosecution's burden here, and they didn't meet it.
Thank you, Mrs. Zarraga. Let me hear from the people.
Yes, may it please the court, Sharon Knight for the people. And I'd like to respond to my adversary's comments. I'm going to go backwards. I'm going to start from the 83 days post-readiness when defense counsel did not appear. The case of People v. Rouse is completely, it's not analogous to the matter here. In that case, I don't think it's accurate for you to say that counsel did not appear for the defendant. There was an attorney there for the defendant, and having an attorney from a public defender service present at the call of a case does not equal no attorney. Okay, and what I'm going to say to that is that this case is analogous to People v. Barden, where the assigned attorney wanted to try the case, was not available because they were on another case, on trial in another case, and they gave availability dates to the stand-in counsel. And that's exactly what happened here. Standing counsel affirmatively. But that's not the end of the inquiry, counsel. Isn't that right? As your adversary pointed out, it is the people that have the obligation to declare their readiness at each and every adjournment date. Every single time. Well, that's not true. It is your obligation. It's not true. Really? People v. Cortez says that the people are not required. Is she correct that the 2 prior adjourned dates prior to the one at issue here, the people did not answer ready? Is that accurate? It's accurate, but it was then not in any way due to the people's unpreparedness.
Ms. Knight, I will suggest that you allow the justice to ask the question. I apologize. It works better that way. Justice Mansonet?
Yes. Do you need me to ask the question again? No, I don't. I just would like to explain the reason that the people stated not ready on those 2 dates. It had nothing to do with whether or not the prosecutor was prepared to go to trial. The first time it was because the prosecutor was on a training, and the second time it was because a police officer was injured. So it had nothing to do with whether or not the prosecutor was. For 30-30 purposes, that is irrelevant. Both of those days would still be chargeable to the people, even if the assigned ADA would have been ready, but for X, Y, and Z. So with all due respect, that's irrelevant. The question is on the next date, when now two consecutive adjourned dates, the people have not been able to answer ready for whatever reason. Now you have a 3rd adjourned date. You're saying that under the case law, the people have no obligation to state their readiness for the record? They don't have an obligation. They do not have to state ready at every single appearance. It's not a requirement. And my adversary is trying to basically accuse our readiness of being illusory, and that's not the case here. Because as I stated, the reason for those not ready statements had nothing to do with the people's level of preparedness on the case. Nothing at all. And I just would like to go back that Did the people file statements of readiness after those adjournments when they weren't your fault in order to communicate to the court that the people were ready?
No, we were charged for that time.
Okay.
So what I was saying before, and I also just want to point out that in Leota and Nunez, the people stated not ready at the beginning of the call and requested time. So that's not the case here at all. Here,
is that required for the court to find that the people are charged with time, that you admit it?
No, it's not required.
Okay.
But the stand-in counsel in no way presented herself as the assigned counsel. The way she introduced herself to the court was—
Counsel, I mean, I can't even believe that that argument is being made, okay? Legal aid attorneys, public defender attorneys from Bronx defender, Brooklyn defender, whatever borough it comes from, you know that those attorneys are charged with covering each other's cases. And if one lawyer died today, another legal aid attorney or another Bronx defender attorney would have to step in.
My point is that the standing counsel was not prepared, nor did she want to go to trial on this case.
Is that on the record?
Assigned attorney gave her availability dates.
Did the attorney who stood up on the case say, I am not prepared to try this case if you send me out, Judge?
Well, of course not.
Okay.
But I do not think that she would risk getting an ineffective assistance of counsel claim on an appeal for something that she never intended to get called out to trial for. There's a reason the assigned counsel gave her availability dates to provide to the court. It's because that was her case, like in Barden, and she wanted to try that case, but was unavailable at this point. And as far as with Rouse, Rouse said that the defendant had counsel because during the adjournment period, counsel was assigned. Here, during the adjournment and available.
But in that case, would you not agree with me that in that case, an attorney who was just assigned a case likewise is not ready to proceed to trial for fear of ineffective assistance of counsel? So if the court in that case found that that attorney who was just assigned constitutes counsel, then I don't see how you can argue that a attorney from someone's law office, especially in an outfit like Legal Aid or Bronx Defender or one of the defender outfits, is not.
I'm not saying that she did not have counsel. I'm saying that counsel was not available during that adjournment period like counsel was in Rouse. She was not available. She was on another trial.
Okay, thank you, Ms. Knight.
Can I address the 83 days quickly? The 93 days?
I'll give you 30 seconds. Go ahead.
Okay. She was saying that the people that we knew that that June did not have her memory back. That's not true. We were having problems getting the hip assigned and the medical records. First of all, we also didn't know if and when June would recover her memory. There's nowhere in any medical records which state that her memory loss was permanent. And also, we would not be able to call a physician if we did not have the medical records. And as far as the other point with the verdicts being legally sufficient, I refer you to my papers. Thank you.
Thank you. Ms. Lizarraga, you have 2 minutes rebuttal.
Thank you, Your Honor. Just a few points briefly. So on the 83 days at the two preceding appearances, which were on March 24, 2015 and April 30, 2015, at both of those appearances, the prosecutor said it was not ready and those periods were properly charged by the court below. So at the appearance on July 8, 2015, at which the 83-day adjournment was granted, the prosecutor had the duty to make the record clear on its state of readiness. And Cortez actually says that. Respondent invokes Cortez, saying that you don't necessarily have to announce readiness at every appearance. But Cortez also says if there has been a substantial break in the proceedings, the prosecution has the obligation to make the record clear so that the court is not, after the fact, left to guesswork, which is the case here. And under those facts, the prosecution, who has the burden to make the record clear, assumes responsibility for the delay, and it must be charged to them. I also want to make clear that Barden, the Court of Appeals case cited by the respondent, did not even apply the without counsel exclusion. It's not true that counsel did not appear at the appearance. Instead, what was at issue in that case was that counsel was actually there on the court dated issue, and she was objecting to the adjourn date requested by the prosecution. That's a very different circumstance and actually involves the consent or request exclusion, not the without counsel exclusion, which respondent is saying applies where there was no attorney even at the appearance, which factually was also not the case, as Your Honor points out. There was an attorney present at this appearance, and the prosecutor had the burden to make the record clear on the basis for the adjournment, and otherwise it is charged to them. And unless Your Honors have any more questions?
I think we're good. You still got 2 seconds to go.
Well, in that case, Your Honor, because this
Well, they already expired, Ms.
Okay, because it was obtained in violation of 3030, we ask that this court reverse the conviction and dismiss the indictment. Thank you.
Thank you so much, Ms. Knight, Mrs. Arraga. Thank you for good arguments. Next case on the calendar is Philadelphia versus Kendall. Okay, Mr. Brager, who's appearing for Appellate Philadelphia Insurance?
Your Honor, my name is Bragar, but that's not the right case.
Okay. No, I saw you in the screen. I'm not sure who's representing Philadelphia Insurance. Okay. Counsel for Kendall, are you available for responding? Okay. Next case is Harvard Steel versus Bain.
Good afternoon, Your Honor. Matthew Garvey, on behalf of the appellant Harvard Steel. May I proceed?
You may proceed, Mr. Garvey.
Thank you. Your Honors, it's our request that there be a reversal of the lower court's dismissal of our complaint based upon CPLR 3211A4. We believe it was improper on both bases, that there's another action pending between the same parties on with same cause of actions. Neither of those requirements were met, Your Honor. The other action that was referred to is a federal district court action, and that action was brought by two corporations that were formed ostensibly.
Was Mr. Bain a party to the Southern District litigation?
No, he was not.
Does that matter?
It matters dramatically, yes, Your Honor.
Tell me why.
Well, because what he had had Gelstar Holdings LLC, and he had a company called DSB Holdings LLC, which was an assignee of some of the assets of a company called Gelstar LLC, which we understand was Mr. Bain's LLC. But that action was brought down to a single cause of action by the Second Circuit for an implied covenant of good faith and fair dealing based upon non-payment of invoices. And this is a case also that the Second Circuit, when they remanded the case, they dismissed every other cause of action that had been brought except for one, which was this implied covenant of good faith and fair dealing. And the Second Circuit even stated in its opinion that they felt that that cause of action was likely to be dismissed on summary judgment. So that was the characteristic, that was the setting of that case at the time that we had commenced the instant action of Harvard Steel against Daniel Bain personally.
But Mr. Bain, everything that the alleged misrepresentations that were made and Mr. Bain's conduct was always in behalf of Gulfstar and DSB, right?
No, Your Honor. DSB didn't even exist at the time.
Okay.
DSB was created long afterwards, as I understand it, and it was long after Gulfstar basically went insolvent. And
so why? That's the part that I don't understand. So then, why, given your 14th affirmative defense, why was Mr. Bain not originally joined in that federal suit?
Well, that probably would have required
because the 14th affirmative defense is premised on his personal conduct, right?
It is premised upon the conduct of Gulfstar. It says and the 14th affirmative defense says, to the extent Gulfstar and Harvard entered into a contract. Neither Gulfstar nor Mr. Bain are parties to that action. Part of the original complaint that the plaintiffs in the federal district court action had brought was a breach of contract action. And this was an affirmative defense to that.
Counsel, this is Judge Scarpula, and the affirmative defense was that there were misrepresentations about what Gulfstar could do. That was that affirmative defense. And therefore, right, that was that 14th affirmative defense was there were misrepresentations about what Gulfstar couldn't do with respect to processing the steel, right?
Processing the steel.
And that's what you're alleging in your action in Supreme Court, is that the guy who entered into the joint venture on behalf of Gulfstar misrepresented what Gulfstar could do with respect to the steel, correct?
Well,
he didn't represent it on his own behalf. He's not processing the steel. The company's processing the steel. And your allegation in the action in front of Judge Borak was that the company, through him, misrepresented what it could do. Correct?
That's correct. It did misrepresent.
And that's the 14th affirmative defense, which is Gulfstar misrepresented what it could do with respect to the steel. Correct?
Correct, Your Honor. If Gulfstar was a party to the federal court action, I would say that's correct. But Gulfstar isn't. Gulfstar is an insolvent company that now has DSB Holdings as an assignee as a party to that action.
Wait a second. So, Gulfstar was never a party to the federal action?
Never.
Oh, wait. I thought, well, okay.
I thought they were. I thought Mr. Bain wasn't.
Right. Mr.
Neither
Bain
was Gulfstar. Neither was Gulfstar. The plaintiffs in this is very important, Your Honor. The plaintiffs in the federal district court action were Gulfstar Holdings LLC.
Oh, the parent. I'm sorry. It was the parent company.
And right. DSB Holdings LLC as an assignee, and it's right on the record on appeal on page 46 identifies what the parties are in that action. And it says that the plaintiff's DSB Holdings LLC is a limited liability company with its principal place of business located in New York. DSB is the assignee of all of the right, title, and interest of Gulfstar's non-plant and equipment assets, including, among other things, any potential causes of action of Gulfstar. But
so
they are not.
The 14th affirmative defense had been pled because it's saying that Gulfstar made some misrepresentations.
Because
so how could it have been pled as an affirmative defense if it wasn't a party?
Because the claim in the federal district court action is monies owed to Gulfstar. That's why that was pled. Now, we would have to pierce not one, but two corporate veils in order to get to Mr. Bain, who committed the fraud. We would have to go through DSB Holdings LLC as an assignee of Gulfstar, bring Gulfstar in, pierce that corporate veil, and then get to Mr. Bain. That's the whole idea of what they created was that shield to prevent us from getting to Mr. Bain.
Thank you, Mr. Garvey. Let me hear from Bain.
Good afternoon, Your Honors. This is Anthony Croze on behalf of Defendant Daniel Bain. My apologies. First, I think the critical component that has been touched on several times is the fact that the 14th affirmative defense was indeed pled. And that directly brings Daniel Bain into question in the federal court action. And if they had not, they would have already joined him in that action, and that would have been the easiest way to resolve this action in full. I apologize. Is there feedback on your end as well?
No.
Well, let's talk about counsel. This is Judge Scarpullo. What about there was an identity of issues between the two actions, correct?
Issues? Well, they all stem from the same transactions and the same substantial issues. Again, I would point to there is a case law in my brief where we discuss the fact that the main issue is going to be whether or not it stemmed from the same series of transactions and occurrences, and this does. This all stems from the same.
No, let me ask you a different way. In the federal action, the question was whether or not after the JV was formed, whether or not there was an improper attempt to take it over. Correct. That's the federal action, correct? And the state action was, you told me that this company could process this much steel, and that was not true. Those are two totally separate claims, right?
Well, I think those issues would still fall within the same series of transactions. And specifically going back to the 14th affirmative offense, I mean, that's why that was brought in, because that was a misrepresentation alleged as a shield in the federal court action, but now is attempted to be used as a sword. And we would have the same position that if Harvard Steel had intended to bring Mr. Bain in, the best way would have been to resolve the entire claims in the federal court action through joinder.
So
and I would also add.
So they should have joined Mr. Bain in the Southern District action.
Correct. And I would also add, Your Honor, that there was in the decision, it was without prejudice to being brought up in the federal court action. And there was never a letter or notice in the federal court action to request a conference or anything along those lines to potentially address bringing Mr. Bain into that action.
Okay.
If there are no further questions, I rest.
I think we're good. Thank you. Mr. Garvey, you got a minute?
Thank you, Your Honor.
Thank you, Your Honors. You're completely correct, Justice Scapula. The two causes of action are entirely different. And whereas in the federal district court action, they're using these shielding LLCs to bring a claim that there was some destructive course of action to harm them, and therefore they're looking for payment of their bills. Whereas in our action, it is an action for fraud, and the idea of joinder was never brought up before today. It was always an issue of whether or not there were the same causes of action and they were the same parties. And we submit that neither one of those were met. Thank you.
Okay, thank you. Hopkinson.
Thank you. Good afternoon, Your Honors, and may it please the court. My name is Alan Sash from the law firm of McLaughlin and Stern. Appellant's motion for summary judgment should have been granted below. Appellant met all three elements for a common law broker commission as a matter of law. There are three elements. First one is that appellant was a duly licensed broker, and he was recognized as such in the lease. The second is that the appellant had an implied contract with the respondent.
Counsel.
Yes, Your Honor.
Wasn't the agreement, the brokerage commission, contingent upon the tenant obtaining a special permit?
No, there was never an agreement that was signed by either party. Both parties admit that was just a draft. That brokerage agreement, and you could see in the record, is redlined and not signed by either party because they couldn't agree on it. And all parties agree that they couldn't agree on it.
So how do we have a meeting of the minds such that would require action here by the defendants?
Because all three elements for a common law brokerage commission were actually agreed to.
Counsel, but there was a very specific arrangement here, and there was no question that a special permit for the client that you brought to the table to be able to run the daycare business that they wanted to utilize the space for. Isn't that right?
That's right, Your Honor.
And without that special permit, the tenant would not could not run his business out of the space and therefore would not rent the space. So why should your client get a commission for a lease that ultimately was not consummated?
Well, the lease was signed and they kept
Yes, but there was never rent paid because there was never a special permit. He was permitted to terminate the lease because the permit was denied. And so the entire intent, the entire purpose of the contract could not be fulfilled.
Right. I mean, the lease itself says that it's null and void. The BSA special variance is not granted, right?
You're correct, Justice Acosta, but I think it's important not to confuse the contingency in the lease with any alleged contingency in the brokerage commission. And
but there's no agreement. You said yourself that the parties could not agree to the terms. So, you have a lease that ultimately was terminated and declared null and void for failure to meet the condition precedent.
Well, there are three elements for a common law commission, and we have met all three as a matter of law.
Counsel, yes, you keep on telling us what those things are, and we know them, right? But that's not the issue here. And you cannot keep on ignoring the big elephant in the room. How do we get past the fact that this lease was declared null and void?
Well, the Court of Appeals and this court as well has held for over a century that unless there's a contingency stating otherwise, and here no one agreed to the contingency and everyone agrees on that, a broker earns his commission once a lease is signed. At that point, his right to a commission is triggered, and there are some examples.
At least that ultimately was null and void because the condition was not met. But wasn't even in your own you yourself prepare a proposal as a counteroffer, right? In which the tenant had 7 months to get the BSA approval. So even your counteroffer require the meeting of that condition.
Well, Your Honor, that is correct, but there's a twist to that. In our counterproposal, we agreed to that condition if they agreed to give us additional commission on future lease renewals and extensions. They would not agree to that. So that was off the table. And I know my time is probably running out, so I just want to say that there are plenty of cases in our brief that we cite where the actual landlord or the seller did not receive any benefit, but the broker was still entitled to a commission. I'll just give you a few quick examples.
Not only did this landlord not receive a benefit, but it inured to his detriment because he had this premises off the market this entire time while they attempted to work with this potential tenant to get the special permit. So I don't see how just in terms of basic fairness, you can hold the position you're holding.
Well, I think that the common law addresses that, because my client worked for 14 months without getting paid, and the landlord always said—
Was your client part of the process of trying to get the special permit?
No.
So after introducing the client, taking the client to see the premises, and then trying to negotiate their own commission brokerage agreement, what extra work did your client do?
Oh, well, in our brief, we set out that not only did he find the location, and he called the daycare, and he went to the landlord, and he walked through with at least twice.
Counsel, you are repeating everything I just said.
Oh, I'm just going in chronological
But
order.
it doesn't help you. You're running out of time and you're repeating what I just said.
You have run out of time. You're way over, Mr. Sides. Thank you. Mr. Braga?
May it please the court, I am Ray Bragar, Eagle and Squire, representing the defendant. Mr. Sash's cases that he refers to all involved hypothetical situations where nobody knew was going to happen after a lease or contract was signed. All the cases that we rely upon involve situations where the lease or the contract of sale had a special permit or variance provided in it, and in those cases, no commission was deemed to be owing. As to the draft agreements, what they show is that the plaintiff did not expect to receive a commission unless the special permit was issued. I agree, they're only drafts, but the drafts written by the plaintiff called for a quarter of its commission to be paid only after the special permit was issued. Without the special permit, it had no expectation of payment and therefore no quantum merit. I yield the rest of my time.
Thank you, Mr. Braga. Mr. Sash, you get 1 minute.
Thank you. The examples I was talking about before, where the broker was entitled to a commission even though the landlord didn't receive any benefit, was when a house went on fire before closing but after the contract was signed. 2, where there was a defect in title, so it couldn't pass. 3, the purchaser refused to consummate the deal. And 4, the vendee elected not to perform. And in those cases cited in our brief, the broker was entitled to a commission because he did his job, even though the landlord received no benefit. Thank you.
Thank you. Thank you both. McCabe versus Coman.
Good afternoon, Your Honors. May it please the court, Rachel Bevins of Cozen O'Connor for appellant Mr. McCabe.
Good afternoon, counsel.
So Mr. McCabe entered into the at-issue employment agreement with defendant Command, which he believed afforded him a base salary, as well as a series of commission payments that were paid both during his employment and post-termination for his lifetime. In
perpetuity?
For his lifetime. So as a result of his contribution to the SCAP's model. Well, he did not expect it to continue after he died. He didn't expect to be able to pass it on to his heirs, but as a result of his contributions to the actual module, he believed that he reads the agreement to state that he was entitled to commission payments after his employment.
But counsel, doesn't that read Section 8 out of the contract entirely? You know, that deals with the commissions in question, Section 8.
So Section 8 contemplates both during and after employment, just as Section 4 contemplates both during and after employment. So I think, the trial court's decision kind of says Section 4 is during employment, Section 8 is after, but both, if you read both, you can see that both would contemplate before.
Well, what's the point of Section 8? Section 8 has a 3-year limitation, correct?
On a different type of commission.
Okay, that's the distinction you're making. I thought these were both revenue produced from SCAP's modules.
They are, but I think it depends what whether it was commissions that he brought in specifically or whether they're commissions just of the module generally as a result of his contributions to the module.
Okay. Okay, thank you, Ms. Bevins. Let me hear from the respondents.
Good afternoon, Your Honors. Jared Limbach from Donnelly, Minter, and Kelly. May it please the court?
Good afternoon, Mr. Leback. You may proceed.
I know we're at the end of the calendar. I know the court is familiar with the papers, so subject to any questions Your Honors may have, I'm going to try to move quickly through the material and just hit the high notes, okay? As the court is aware, there's two ways to interpret a contract. There's within the four corners of the document if the language is deemed clear, and then there's also through extrinsic evidence if the language is deemed ambiguous. In this case, the court did both analyses and it reached the same conclusion, that the agreement does not require indefinite post-termination payments to the plaintiff. Now, looking within the four corners of the document, I think Justice Moulton hit the nail on the head just a moment ago, Justice Acosta. It's important to look at under New York law, you have the entire agreement as opposed to just isolated sections. Here, there are two sections that work together to explain the parties' intent in this agreement. They have Section 4 and Section 8A, and I do want to parse Section 8A from Section 8B. Counsel just indicated that Section 8 deals with both compensation during employment and compensation after employment. The heading for Section 8 is divided by a slash. It is essentially post-termination compensation and an option to purchase. The option to purchase could theoretically have accrued during the employment. The post-termination compensation, which I think is called additional compensation, is clearly only after the term of employment. The separation of those two sections for what is overlapping compensation, to Justice Moulton's question, they both have to do with SCAP's revenue, makes it clear that the parties intended those two sections to deal with distinct time periods. I also think, or I would submit, looking just at the language of where the appellant's entire case rests, I think what is not said is just as important as what is said in the contract. Section 8A specifically states that it applies after the termination of employment. Section 4 does not say that. It does not call for perpetual commissions. It does not call for lifetime commissions. It does not call for...
Let me ask you a question. It's just the defendant paid roughly $720,000, a lot of money.
Yes.
Pursuant to paragraph 8A. And so did anybody calculate if Mr. McCabe is correct that he's entitled to these commissions in perpetuity? Would that be more than that? Would it be millions of dollars? Where would it end up? How much would you be in the hole to Mr. McCabe if you had to pay him in perpetuity? Say he lived, an actuarial lifetime.
Yes, Your Honor. That would. I'm not sure the exact number of zeros, but we are talking about orders of magnitude. I cannot tell you as I sit here today, Mr. McCabe's life expectancy, but we are certainly talking about a much, much greater sum of money. I don't believe anybody has calculated specifically, at an actuarial level what that would look like, but it is certainly very different from what you would expect to see contemplated in an agreement that was negotiated for an employee at this level.
And counsel, this is Judge Scarpula. If you would expect if somebody was going to get paid for the rest of their lifetime, that would be in the contract, correct?
Yes, yes.
If you're talking about millions of dollars of compensation, that wouldn't sort of be something you do by implication.
Yes,
right?
Your Honor.
Would expect that to be in the contract.
That's exactly right. And we haven't seen any case that would allow to sort of impute indefinite or lifetime earnings based on the absence of limiting language in a small subsection within, especially where that interpretation is contrary to the structure of the agreement itself. I know my time is limited. I'd be remiss if I didn't also mention that if the court decides to look outside of the four corners of the agreement, Your Honors are going to see that while this agreement was negotiated, the plaintiff expressly sought rights that would allow him to profit from SCAPs in perpetuity, essentially is what he's seeking now in this case. That was considered and very clearly command. I have to quote Command's then CFO, who put in a memo, quote, "Why would we pay 5% commission to anyone forever?" It was just completely out of bounds for the company. It wasn't brought up again during negotiations. In fact, we have multiple emails from Mr. McCabe himself that are in the record where he asks both before signing the agreement and during the agreement about his 3 years of commissions after termination. Even after the employment was terminated because Mr. McCabe resigned, His attorney wrote a letter, and again, I have to quote it. Surviving the term of the agreement are obligations of commission payments for a period of 3 years by Command Financial to Mr. McCabe as set forth in Section 8, end quote. So Mr. McCabe was talking about 3 years. His attorney was talking about 3 years, even when demanding commissions after the employment ended.
But we don't need to go there if we don't read the contract that way, right?
No, you don't, Your Honor. I just would be remiss if I didn't mention it. It is my only chance to speak with you.
I got you. Thank you, Mr. Limbach.
Thank you.
Bevins, we good?
Yeah, I would just say that, if the court were to find the agreement ambiguous, we haven't even done party depositions. We're like in the very initial stages of discovery. And if the agreement is found to be ambiguous, it should be remanded to the state court for discovery.
Okay, thank you so much. Thank you both. This concludes today's session of the Appellate Division First Department. Have a good night.